Shane List, and on deck is Anthony Zoll. Mr. List, welcome to House Education. You would indicate you want to speak for 5 minutes. If you could make it to 3, that would be great.
Well, as Penny kind of already touched on, I'm a trial lawyer, so keeping my comments limited is difficult because I like to hear myself speak, but I will try my best. By the way, it's Sean List. I'm an attorney in Manchester at the firm Backus, Meyer & Branch. My primary focuses in law practice are actually employment discrimination cases, criminal defense, and I also do gun law. What I mean by I do gun law is that obviously it touches on my criminal defense practice, but I also do FFL advising. I teach gun law courses to other lawyers for New Hampshire bar credit. They get credit for going to those. I also teach members of the public through an insurance company that insures people who conceal carry, so members of the public come out who would like to essentially understand New Hampshire gun law and also understand how they can better be a responsible concealed carry holder. So I'm going to try to address some of the more nuanced points of this law and what my concerns are. Now, this issue is deeply personal to me. I come from a family of educators. My sister is an educator. I represent teachers. And the purpose of this hearing is not lost on me, and I do appreciate that these issues are being discussed. That being said, I know coming and testifying on this is directly against my business interests because of the number of lawsuits that are likely to spiral out of this bill. Lawsuits that will have my phone ringing. You know, the Harvard Business School did a study back in 2016 about the impact of mass shooting incidents on gun violence. And they found that although mass shootings make up a very marginal percentage of the number of gun crimes in the United States, they're 80 times more likely to cause discussion about gun policy. And that's interesting when you look at the FBI crime statistics database and you find that mass shootings represent less than 1% of the crimes that occur. I just find it interesting with the dialogue that we're having today. So getting right into the law. First off, I heard someone speaking earlier who said that gun restrictions are a constitutional right. That is not correct. There is a body of constitutional law going back to 1875. That was the Cruikshank case, really the first time the Second Amendment was addressed by the U.S. Supreme Court. Interestingly enough, that was a case where people were held liable for discriminating against, in the Reconstruction era South, discriminating against freed slaves who were trying to protect an election and disarming those folks. So fast forward, what was being discussed were the cases of D.C. versus Heller and Chicago versus McDonald. Now in D.C. versus Heller, it is true that Justice Scalia's opinion mentioned that his opinion was not to be interpreted as forbidding restrictions in school zones. That being said, the Second Amendment is still a fundamental right, which means that in order to pass restrictions on the Second Amendment, the government has to prove that they have a compelling justification and a compelling interest in the manner in which they're infringing upon that right. The legislation that's currently being considered has no basis in reality. I'm very concerned with both House Bill 101 and 564 regarding what is the definition of a school zone. So I can tell that there are certain provisions that were lifted straight out of the Gun-Free School Zones Act of 1990, but that act was deeply considered so that exceptions applied to avoid creating an undue hardship on individual citizens. Such exceptions include you could carry in a school zone if you have a concealed carry license that involved a background check. Even more importantly, and I heard an FFL holder kind of address this issue earlier, there's an exception for people who have property abutting school zones. So if you have property abutting a school zone, you could still own firearms. Under this bill, it refers to RSA 193D. It says the definition of school zone, well, the term actually is safe school zone in 193D. And the way that law defines safe school zone is an area inclusive of any school property or school buses. I don't know what that means. Does that mean that you can see the school? Does that mean that you're in the area where the school is? It's very poorly defined. So I think there's going to be, especially if the federal definition of school zone is imported, there's going to be significant litigation because of this bill. I think that with House Bill 564, the idea that a concealed carry holder has to unload their firearm, put it in a locked container to drop their kid off, and then do the reverse is going to increase the likelihood of accidents, because rather than safely in a holster, you have someone racking the slide and trying to lock it at a gas station down the street. There are a lot of unintended consequences here. The last point that I will make is this. My practice has me kind of rubbing elbows with individuals that are, let's just say, unsavory at times. I go to businesses and I say, you've discriminated against this person. That doesn't exactly build me a fan club. I carry a firearm to protect myself. I have clients that are domestic violence victims that do the same. This bill tells a domestic violence victim, if you're taking your kid to school, during the drop-off you have to disarm yourself so your potential, abuser has the opportunity to attack you. Firearms are the great equalizer, and that's why they're a fundamental liberty interest. I'd be happy to entertain any questions.
Thank you, Mr. List. Are there questions of Attorney List? None. Mr. Perry, thank you very much. Now call...
Crop TV.